What are their names, please?
Amina is the older one, and Amira is the younger one, the one that's still on the order.
And sir, for the younger one, when does she graduate from high school?
Well, she's scheduled to graduate this year, which would be, I guess, in June uh, of 2024.
And then her birthday is when, sir?
June 29th of this year, be 18, but she was born in 2006.
And sir, were you able to hear my opening statement to the court before your case?
Before the last case, the prior case, ma'am?
Just now, sir, this summary of what I believe to be the facts.
Oh, yes, ma'am. I did hear that. Yes, ma'am. Maybe I didn't understand 100% of it, but yeah, but it sounds about right.
And sir, as far as your position on this case, is it correct that you were wanting the support for your younger child to remain the same given how much time is left for her on the case?
Yes, ma'am. I mean, this was ruled, wow, a bunch of years ago. I don't know, 17, 18, 16 years ago. And I thought everything was taken care of. I thought it was unfair then, but I lived with it all these years. So I'm kind of surprised that there's any request for any changes now, especially the properties were addressed. She's
Okay,
received.
sir. I'm sorry, you're going way past the question. Okay, when the state will flesh this out, but right now, just answer the question and stop. Thank you.
Yes, sir. Will do.
And so, Mr. Mabruk, at this time, are you aware of any changes that have occurred since the decree of divorce set the support and addressed the properties you just mentioned?
Maybe I didn't understand the question fully.
This hearing centers on a late-stage child support modification request with only one minor child remaining under the order. The court immediately establishes the legal reality: the child will turn 18 and graduate within months, placing strict limits on what relief is even possible. The state makes clear from the outset that no obvious change in circumstances has been shown. Properties referenced by the mother were already addressed in the divorce decree. From the beginning, the judge signals caution: this court will not relitigate settled issues without lawful grounds, especially when the timeline is closing rapidly.
Am I aware of any changes for what?
Changes in circumstances for you, Ms. Mabruk, or your children that have changed anything since the divorce decree that addressed the properties you mentioned?
No, ma'am. I just know that no changes that I'm aware of.
Thank you, sir. Your Honor, I pass this witness.
All right, then, sir, we're still operating under your original divorce decree?
Yes, sir. As far as I know, unless there's something else out there that I'm aware of. But yes, sir.
All right, and what did you do for a living at the time of your divorce, sir?
Well, at that point, I just retired, and I've taken a job. I believe at that point I was working overseas or thereabouts, but I had several jobs since I've retired.
Okay,
And at the same,
stop. I just want to know about that. And
yeah.
I'm sorry, and what was the amount of child support ordered originally?
There was stipulations there, sir. There was a house involved that she was residing in.
Stop. Again,
Yeah.
sir, I don't get the math. Ms. Mongat, what's the...
As testimony begins, the judge carefully enforces courtroom discipline. Witnesses are sworn in, instructed to remain still, and reminded to answer only the question asked. When testimony strays into irrelevant explanations or emotional arguments, the judge cuts it off firmly. This is not personal, it is procedural. The court makes clear that credibility comes from precision, not speeches. Every interruption reinforces a core message: this court operates on evidence, not narratives. The judge's tone reflects experience, ensuring the hearing stays focused on what the law allows, not what either party wishes it could allow.
Current child support obligation, please.
It is $1,350 per month.
Is that with the older child having emancipated, or was that the original amount for both kids?
So that's with the original, with the older child having emancipated. Initially,
right.
it was 1687.50.
All right, thank you. All right then, and did this I got citation in November. Did the state do account what the current child support would be with the one child remaining?
Sorry, Honor, what was that question?
You do a calculation of what the current child support would be technically going forward since with the one child remaining at this time.
Well, Your Honor, it's our understanding that the amount would actually go down, and I apologize, I misspoke. The parties had a modification in 2013, so after the divorce decree, which set these current amounts.
Okay. All right then. Thank you. So at this, okay, thank you. That got my information. Thank you very much, sir. And Mr. Bongard, you can call your next witness, please. Thank you.
Thank you, Your Honor.
Yeah.
The state calls Ms. Mabrouk. Ma'am, what is your full name?
The father testifies that no material changes have occurred since the last modification in 2013. He confirms continued compliance with the existing order and expresses surprise that modification is even being sought so late. While he briefly drifts into commentary, the court immediately redirects him. His testimony establishes consistency, the same order, the same obligation, the same understanding for years. Crucially, he denies any new income changes tied to property ownership. This testimony reinforces the state's position. Without a material change in circumstances, modification becomes legally difficult, especially with the child nearing emancipation.
My name is Nashwa Mabrouk.
And is it correct, ma'am, that you're the mother of the two girls mentioned in this case by Mr. Mabrouk?
Yes, ma'am.
Were you able to hear my opening statement to the court of the disagreements between the three of us?
Yes, ma'am.
And ma'am, was I correct in telling this court that your last order that set Mr. Mabrouk's support was the 2013 modification after your divorce decree?
Yes, ma'am.
And so, ma'am, since that modification in 2013, what has changed for your family?
Before the marriage, was wrong. No, this
Okay.
is after our marriage.
Okay, well,
So,
the state has not gotten there yet, ma'am. So let the state continue with that information and get that testimony from you. For right now, just listen to the one question just asked and then answer that question and stop. Thank you.
okay.
All right, state may proceed.
Thank you, Your Honor.
The court admits the state's financial activity report, confirming child support payment history through official channels. No objections are raised. This document carries significant weight. It replaces accusation with verified data. The judge emphasizes that these records show compliance, not arrears. Emotional claims of non-payment cannot overcome documented evidence. This moment underscores a recurring courtroom reality. Paperwork often speaks louder than testimony. By admitting the exhibit, the court anchors its decision-making in objective financial history rather than conflicting personal perceptions, narrowing the scope of what remains legally disputable.
And ma'am, when we did the modification in 2013, Mr. Mabrouk was the person maintaining your daughter's health and dental coverage, correct?
Yes.
And he's still doing that today?
Yes, ma'am.
And then as far as his income, were you aware of him changing jobs or having a change in income?
Of course, there is no contact. I can know what his work, what his income. I can't, but I know he can support the kids because even there are 18. He knows by our belief he's still responsible. It's like they turn 18 and
Okay,
he's not
ma'am,
$1 for any.
Ma'am,
for
stop, please. Order in the court.
Okay, I'm sorry.
All right, here's the deal, ma'am. Right now, I'm looking at ordering child support. I can only order child support for another technically 3 months. If the child is graduating from high school
The mother testifies emotionally, focusing on hardship, cultural expectations, and moral responsibility. However, the judge repeatedly intervenes to clarify limits. Statements about mediation, religion, and parental obligation beyond age 18 are excluded or corrected. The court acknowledges her frustration but explains that Texas law governs, not belief, fairness, or morality. This exchange highlights a painful divide: what feels right versus what is legally enforceable. Despite sympathy, the judge cannot base rulings on faith-based responsibility or past grievances unrelated to statutory child support standards.
Over the age of 18, child support stops in the state of Texas. I can order child support modification up until then. If the court finds there's been a change of circumstance and it warrants the modification, I can order that modification all the way back to start the first day of December. And that's the first day of the month after both of y'all were served with paperwork. But ma'am, any child support order I do will only go through the 1st of June of this year. That's it. I can't go any further than that because that's all the law requires. So I'm gonna let the state continue. So at best, ma'am, I can modify the child support going forward from today, or I can modify it going backwards. But ma'am, from the 1st of December, but that means it can go down or it can go up. But that's all based on the circumstances, ma'am. So I'll let the state continue with questions. You may proceed, Ms. Bongat.
Thank you, Your Honor. And ma'am, as far as the properties that I mentioned in my opening statement, was I correct in letting the court know that that was something you were wanting?
At this stage, the judge delivers a clear legal explanation. Child support in Texas ends when a child turns 18 and graduates high school. No exceptions apply here. Retroactive modification is limited. Forward-looking support beyond June is impossible under law. The judge carefully explains months, dates, and limits so there is no misunderstanding. This moment is pivotal. The courtroom shifts from debate to resolution. The judge makes it unmistakably clear that the court's authority ends where the statute ends, regardless of emotional appeals.